We'll have questions regarding family law. Live at 5's Family First contributor Sonia Kaufman joins us now with some legal advice. And Sonia, boy, do I have some questions for you from our viewers. One writes in, can he refuse to pay child support because he wants a DNA test? I guess they're talking about having a child and not having that DNA test yet.
Yes, for a time. The procedure is that they would file a petition to establish child support, and the father or the reported father could ask for a DNA test. And if so, if this is done through the Attorney General's office, then it would take a month to 6 weeks probably to get the results. And if he is the father, he pays for the test. If he's not the father, the state pays. If he is the father, of course, he will pay child support, and it will be retroactive to the date of service of that lawsuit.
So depending on how long you decide to wait for that DNA test, if you are the father, you could be paying a lump sum.
Exactly. So there's really not a way to avoid it if you're the father, but you might delay the start of payment for some time.
Another question from a viewer, do I have to pay back child support if I'm not the father?
Or is he saying that if he's found to have
If he's been paying child support, I guess, and now he's not the father, does he get money back?
Okay, no. If he's been paying the support, then he has to pay according to the court order until the order is changed. So if it's later determined that he's not the father, then it would stop, and then from that point forward he wouldn't have to pay, but he's not going to get the money back.
Wow, okay. How will it affect child support if my ex declares bankruptcy?
Child support is not dischargeable in bankruptcy, so the child support will continue. It may be that a motion to enforce the collection of child support could be a little bit more cumbersome during the bankruptcy because of a stay that's in place, but basically it should not affect the payment of child support.
All right. Is child support taxable?
No.
Not taxable at all,
No.
okay. Can my ex's tax refund be seized to pay back child support?
That's a good question. If there is a lien for back child support and it's enforced through collecting a tax refund, if both parties' names, say your ex and his spouse, if the return is or the refund is made payable to both of them, then yes, that can be seized. But if it's in the name of the spouse only, it would not be.
All right, something to look into. Can an ex-fiancé go to court to get a ring back?
Anybody can go to court, but I don't think they would be successful because a ring is a gift, either an engagement ring or a wedding ring, so I don't think that would work.
All right. Can you legally change your name, and at what age?
Yes, you can legally change your name. If it's a child, then a parent or guardian files a petition asking that the name be changed and stating the reasons for it. If the child is 10 or older, the child needs to join into the petition and consent to that. And it's up to the court whether to grant the name change depending on the reasons for it. If it's to a good reason, say, to help bond with the family unit so that everybody's name is the same, that may be granted. But the court will also look at whether the father whose name is being taken away is involved in the child's life, if they paid their child support. So the court will look at all of the facts. If it's just to alienate that parent, then no, the name won't be changed.
All right, and 10 is the age?
Well, it can be done sooner. It's just that if a child is 10 or older, they have to consent to it.
Okay. My kids cry when I leave them with their father. Should I go back to court to try to have my orders modified?
That's a tough question. That's really hard when the children are unhappy with that transition. But in and of itself, the fact that the children cry is probably not enough to modify the possession and access. But I would want to know the underlying reason for that and look at the total circumstance to see. But the legal standard is whether the circumstances have materially changed since the prior order was entered, and if so, what's in the best interest of the children.
Just keep those communication lines open.
Absolutely.
And talk to your kids. Sonia, we appreciate you stopping by.
Thank you, Kelly.
And if you have a question about family law, you can email us those questions at laf@kfdm.com.